This is William and Lonsdale, a podcast about the legal ecosystem and the fascinating people who make it tick. Today, your host Michael Green speaks with the Honourable John Coldrey. When reflecting on John's work and contribution to the criminal bar in Victoria, the words legendary and iconic are entirely appropriate. Along with his decades defending in criminal cases, John was a founding member of the Criminal Bar Association. He even wrote and performed songs and skits in bar review nights with his close friend and colleague, Frank Vincent. Following in Frank's footsteps, John was one of the first advocates to go to the Northern Territory and work at the Central Australian Aboriginal Legal Service, which then led to his work as Director of Legal Services at the Central Land Council, advocating for Indigenous land rights. Not long after his return to the bar, he was made Victorian DPP, a surprising move for a man who had never prosecuted a single case. In 1999, John was appointed to the Supreme Court of Victoria. He also served as a member of the Adult Parole Board and Chairperson of the Victorian Institute of Forensic Medicine. John has had an exceptional life in the law, but for all the achievements and accolades, one thing is clear in this conversation. Whether with his family and friends, at the bar table or on the bench, John has never lost his sense of humour.
They had a model of the top of the human body and they placed it on the bench near me for the witness to talk about, the doctor. And I remember counsel saying, now doctor, would you have a look at the dummy on the bench? And in what, politicians would call damage control, I blurted out, the one on the far right, please. and anyway, some radio station took it up and I got the award of Beak of the Week for quite unmeritoriously, but...
Our guest this morning in Lives in the Law is the Honourable John Coldrey, formerly a Justice of the Supreme Court of Victoria. Good morning, John.
Morning.
John, back to the start. Essendon, just after the Second World War in Melbourne. You were born there and brought up there. What was life like, late 40s, early 50s, in Essendon?
Well, it was always a magnificent suburb, Michael, as far as I was concerned. It was a place where you could play sport in the street without being run over, and we played a lot of street football, which I suppose you'd describe as character building and scab creating, really, because it was on the bitumen. I was a keen Essendon supporter, and the great footballer of the moment was John Coleman. Well, to be frank, apart from the same first name and the first three letters of our surname, and joint membership of the human race, I had nothing in common with John Coleman, but I wanted to wear a jumper with number 10, which was his number. My mother, shall we say, was slightly underprivileged in the sewing department, and she said she couldn't do 10. And I threw a bit of a tantrum, but she said she could do 11, which was the two strips. And there was a fellow who lived 3 or 4 doors down called Ron McEwen, who was a rover with Essendon at the time and still in the Pantheon, so I settled for that.
A very typical thing to be playing football in the street in those days. I remember it myself. John, what about education? What education or what schools did you go to and how did they lead you into the law?
Well, I went to Aberfeldy State School, and after about a year and a half there it burnt down. I had an alibi. I was home making sure the dog didn't eat my homework. But anyway, it meant that for about the next 3.5 years, we'd go to the school, get on buses, and we were bused to Essendon State School, a lesser school, of course. But in final year, we came back to Aberfeldy, and it was a good school.
And from there, you went on to Essendon High School.
Yep.
And also a good school?
Yes. Terrific teachers there. My father was very keen that I should get to a private school at some stage, and he kind of moved heaven and earth, and finally, Form 3 level, I was able to go to Wesley. But he was a very decent man, my father, and he said, listen, I can get you into Wesley, but it's your choice. do you want to go or not? I said, no, I want to stay at Essendon High. That's where all my mates were. And I didn't want to be at some school where I didn't know the kids. So I finished my education at Essendon High.
Essendon High wouldn't have typically had many kids who went on to do law at that time?
I was the only one in my year. When I first went to the school, there were 10 kids doing matric, as it was called. And, I was the only one eventually that did law. And I can tell you, Michael, it was pretty... my first year at uni was pretty lonely because I didn't know anyone. Well, I did know my mates in other faculties and we often got together for lunch, but apart from that, I was on my own.
And what was law school like then? This is early 60s when you started?
Yeah, 1960. Look, I think the lecturers were pretty good. They taught, unfortunately, most of them using what was called the Socratic method, which meant they came in and they asked questions of the various students and you were supposed to sit in a numbered seat. And I can remember there was a very nice old fella called Frank Marr who taught Introduction to Legal Method, and he'd ask me a question and I go, blah, 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 blah. He was a lovely old man. He'd say, yes, that's a thought. Anyone else?
What about sport? Did you play sport at university?
I did. My first year at uni, not knowing anybody else in the law faculty, I mean, they were nice enough people, but they had their own cliques. And I would think that's probably the loneliest year of my life, first year at uni. But I played a fairly high-level hockey in the top grade for Essendon. And Essendon had a policy that if you went to uni, they would give you a transfer to Melbourne Uni on the basis that when you finished your course, you'd come back. I'm not sure how many did go back, but so I made the top Melbourne University hockey team and made a heap of friends that I've still got 60 years later from the hockey.
I think we can say that those friendships have remained very strong because you've just come back this week from a weekend away with those 60-year friends.
Yes, that's right. A good week. I'm still recovering, Michael.
I hope you didn't play hockey up there, John.
No.
So uni goes, I mean, it was uni and you got through, obviously, and progressed through to articles. Articles in those days, tell us about that. I mean, they don't exist anymore.
Well, in those days you had to do a year with a firm of solicitors. And by that stage I'd become a bit interested in criminal law, really from watching Perry Mason. And
can I just tell our listeners who aren't as old as you and I, John, that Perry Mason was an American TV show about a lawyer who never lost a case.
No, that was very impressive about him. Also impressive was his gorgeous secretary, Della Street, who got the hormones jangling a bit. But anyway, so Ray Dunn, who was a prominent criminal solicitor, used to lecture us in criminal procedure. So I thought it'd be fantastic if I could do my articles with Ray. So I wrote him a letter and I got a reply saying, well, I've got a relative doing articles next year, but if that falls through, I'll contact you. And it fell through and he did contact me. So I did the next, 18 months really with Ray Dunn.
Doing articles in those days, they weren't a structured thing or an organised sort of thing. They could be very different depending where you did your articles. Did you learn a lot from them? Did it prepare you for practice?
Well, I think it did because for at least the first 6 months, I spent all my time sitting opposite Ray Dunn at the bar table when he conducted cases. And he would have been a very good barrister, very good cross-examiner. So I had the benefit of that. Ray was hard to describe Ray by this. He'd been a terrific athlete. He got a blue in water polo, for example, at Melbourne Uni. By the time I was reading or doing my articles with him, you could describe him. He was bald and he had a kind of head like a slightly deflated Puce soccer ball, I'd say, and a huge belly. And I was in his room. I was sat next to the fridge, which he went to quite often, facing a wall. But I could hear everything that went on behind me. He could be quite aggressive. I can remember some solicitor ringing, obviously wanting a settlement in some civil case, and Ray saying, "No, our offer's not going up. The only thing going up is our confidence," and then slamming down the phone. But he took me to an inquest where there'd been a police killing, and I was allowed to carry one of his law books, and we came along and there was a whole heap of photographers and television cameras there. I thought this was pretty good. And He said, he took out the side of his mouth a bit. He said, "This is fame, son, fame." And I thought, well, this fame's pretty good. He said, now, Frank Galbraith will be appearing for the relatives. We've got to get him to do his block. Once we get him to do his block, we'll be right. I thought, oh, yes, Mr. Dunn. Didn't understand much of this, but we get into the courtroom. Oh, shit, it's Jack Galbraith. Well, Jack Galbraith QC was a very able barrister. So he said, it's going to be a bit harder. So anyway, Ray's niggling away as the case goes on, and Jack's getting a bit more and more exasperated. And he says to the magistrate, "Your worship," as they were, "your worship is just trying to wrestle with a greasy pig." Ray would chuckle away. And anyway, we got into the second day, and Jack couldn't really take any more of Ray's niggling. He'd also give a bit back by saying to the magistrate, "Your worship, he's not a well man, your worship," he'd say. But anyway, Ray'd just chuckle at that and keep going. And on the second day, finally Jack Galbraith threw his papers on the table and basically did his block, and Ray led forward. He said, "We've got him, son, we've got him." and we had, but that was Ray.
So you learn about strategy and tactics from Ray as well.
I'm not sure they were the best, but anyhow.
John, you're admitted in 1966, and in that year you also get married. I'd like to say, was it a struggle to support yourselves? My guess would be, as an article clerk, you would have been making no more than $20 a week, literally.
Yes, I think for the first 6 months about 10, and then Ray increased it to 20.
And so what about supporting yourselves, you and your wife, as a newly married couple?
Well, my wife was an art and craft teacher at secondary school, and I suppose basically for a start she supported us, for which I'm very grateful. So that's how we got through, because there's a delay between doing cases and the money starting to flow. Small though it was in those days. I remember going out to a magistrate's court with 3 briefs, and the total came to $51. And I came back and I thought, oh, basic wage is $50. I've made $51 in a day. This isn't bad. But anyhow, it got better.
6 months after you're admitted, so, you're still, I'd say, on the bare bones of your backside, John, financially, I'm assuming, you come to the bar. No reader's course?
No.
How do you learn your advocacy skills? And did it take you a long time to establish a practice?
Well, you had a reading period with a master. So first of all, you could go in there, and it was either 6 or 12 months, I can't remember. And I read with a very able barrister called Kevin Coleman. So you didn't have any rent to pay. You were parked in his room. You could go to court and watch him if you weren't in court yourself. But I'd benefited over the years from A, watching Ray Dunn in action, but B, instructing a whole lot of barristers who were criminal advocates and sitting opposite them at the bar table, often taking notes and watching how they operated. So that was great benefit. And I spent quite a bit of time in the magistrates' court, or the Court of Petty Sessions as they called it then. In fact, I could have got a job as a taxi driver, Michael, orientating myself by the various courts of petty sessions around Melbourne. The good thing really about that area of practice was you had no depositions. You didn't know what witnesses were going to say until the moment they got up in court. So you had to be very agile and good on your feet to work out what line of cross-examination you were going to take. And I also had a practice as if I lost a case, I'd go back and kind of do this post-mortem, trying to work out what went wrong. So it was a kind of process of osmosis. It was the skills in the magistrates' court, or petty sessions as it was called, but also from observing some of the better barristers in action.
You must have established a reasonable practice, because after 3 years you could afford to take a year off and travel overseas. Was that a risk to take that?
I think it was a risk, but I don't know. I don't know whether I was disillusioned, but I wanted a bit of a break from the daily grind. I had a very good practice. I was in court virtually every day. I had a very good clerk in Kevin Foley and Jim Foley, his father. The way it really happened was that I wanted to do a year studying criminology at Cambridge, and I'd done 2 years of criminology at Melbourne. And so we wrote to Cambridge, and I had some referees. And finally the letter came back, and my wife was very disappointed I was knocked back. So in a sort of misplaced gallantry perhaps, they said, well, never mind that. Who'd want to stay in Cambridge for complete year? Let's go around the world. So anyhow.
You were a risk taker, John.
Well, it was quite different in those days. You could get a round-the-world ticket for $2,400. Economy, of course, but as long as you could go anywhere you liked as long as you kept going in the one direction. So we got ourselves a ticket each, round-the-world ticket, and then you could also buy a car duty-free, providing you picked it up in a foreign country. So we bought a Renault 4 for $900. Renault agreed they would buy it back. Eventually we sold it back after 40,000 kilometres for about $600. So it was a pretty cheap vehicle. And we had a Marischal tent, and we camped all over.
You're away for a year. You come back in 1971. Again, what about re-establishing a practice? I mean, do you come back to avoid and you've got to start again like you're a reader?
No, it didn't seem to happen. You see, I've been away 12 months and never lost a case. So that was probably a help.
Enhanced your reputation.
Well, I'd done nothing to damage it in the meantime. So, and Jim and Kevin Foley were terrific. I mean, they just took up where I'd left off, and I found myself getting briefs up in murder trials, which was kind of a great ambition for a criminal lawyer. A lot were with silks, QCs, but I did a number myself as well.
John, I was interested, you did murder trials both on your own and as a junior to a silk at a time when the death penalty was still in force.
Yep.
Did that add a layer or many layers of extra stress and tension to everybody involved in the process? The fact that there was potentially going to be a death penalty imposed?
I don't think so. Well, first of all, I was very fortunate because in the cases I did, there were about 10 of them, while death penalty was still in existence. There were only 2 convictions for murder, and they were both juveniles, so they couldn't be hung, so I never heard the death sentence read out. But I think the reality was that after Ronald Ryan was hung, the public outcry was so great that it was highly unlikely that anybody else was going to be hung unless it was the most heinous crime. And those sort of crimes didn't happen very often. So if you were appearing for the average accused, you weren't really concerned that they'd be hung.
Were you typically looking to get a not guilty verdict for your accused, or was it more often that you were hoping to get it knocked down from murder to manslaughter?
Well, it was both. I think the first case I did, as Rumpole will say, alone and without a leader, was a case where my young client had stabbed somebody. He was being attacked, and the Crown came and said, we'll take a plea to manslaughter. And I said to the client, don't accept the worst you could ever do in this case is manslaughter, and you might get a total acquittal. Well, of course, one effect of that was to increase the pressure on myself, but very fortunately he was totally acquitted, so that worked out. That worked out all right. But I was never personally concerned that any of the people I appeared for would be hung.
Still remaining on this period of time, I guess, when you were still a junior barrister before you were a silk, you appeared before Mr Justice Lush in the Supreme Court, I guess murder trials, and you formed the opinion that he was the best judge you ever appeared before, and you actually tried to model yourself on some of the things he did. What made Mr Justice Lush an outstanding judge?
Well, he had this capacity to isolate the essential issues and explain the issues to the jury in understandable language. And look, he was very encouraging. I can remember you'd cross-examine somebody and sit down. If he thought you'd done a good job and you'd sat down at the right time, you'd kind of get a nod from him, which was very encouraging. And one of the most difficult cases I did was a fellow who'd shot his wife as she was sitting in bed with the 8-year-old daughter next to her. And his defence was that the wife had grabbed at the barrel of the gun and it had discharged. That wouldn't have got him an acquittal, but it might have got him a manslaughter. The real difficulty in the case was trying to cross-examine an 8-year-old girl who'd lost her mother if you put a foot wrong and if the poor child cried, I think that would have been the end. But anyhow, the jury retired and we had to go up and see Justice Lush for some other reason. I went up with the prosecutor and we dealt with that other matter. But then Lush said to me, I don't know how this case is going to turn out, John, but I want to say this. Nobody could have done more for their client than you did. Now, the young barrister hearing that from a senior judge was just fantastic.
And therefore, what impact did it have upon you as a judge?
You don't precisely model yourself on anybody, but because you've got your own personality. But as near as I could, I tried to
and be
model myself
encouraging
on
to
him.
counsel who you thought were doing a good job?
Oh, yeah. I remember on one occasion I had a prosecutor in front of me who lost 2 murders in a row, and he lost 2 in the sense that there were acquittals.
Yeah.
So I rang him and I said, look, don't change anything you're doing. You are prosecuting fairly and properly. Don't worry about those verdicts. You'll get those in the course of your career. Just keep doing what you're doing. And he did. He was a very good prosecutor. Later became a county court judge. So, if you had a chance to encourage people, and I'd been encouraged, so why not encourage others?
Yes, it's a theme that comes across in our podcast all the time, that people who have had successful lives and careers almost invariably have had generous mentors who have helped them. And therefore I guess it's incumbent upon all of us as we get older to try and do the same.
Yeah.
John, you made a comment, there's that old saw in the law that you, in cross-examination, you never ask a question you don't know the answer of, but you actually challenge that.
Well, I think the real approach is never ask a question where you mightn't be able to handle the answer. And in order to be able to handle the answer, you really have to think through the possible answers you might get. And that involves preparation. When we used to instruct students in criminal law, which I did for a while, there were there were actually 7 Ps, but I only give you 5 of them. Proper preparation prevents poor performance. The whole secret is to prepare properly. You're dealing with human lives, and that's part of the profession, but you've got to realise that you've got to make the effort.
John, to lighten things up a bit, tell us about the bar reviews.
Well, the bar reviews were really the idea of a fellow called Dave Ross, QC, who's no longer with us. But they didn't have bar dinners in those days, so they had these dining-in nights. And Ross had the idea that it might be liven them up to have these reviews. Actually, I'm quite wrong. They did have some bar dinners where the guest speaker was usually so boring. So this was a different approach. There were a few of us were involved. I wrote a lot of the stuff. Frank Vincent and I did a poor man's Peter Cook and Dudley Moore exchange where we'd send up senior barristers and judges unmercifully. You could get away with it.
Were they in the room watching it?
Oh, yeah. Most of them were. It was a very small bar in those days, and people don't realise the bar was about 120 people, plus the judges. You could fit in the common room upstairs. I managed to kind of get a few things off my chest. I wrote the Mad Distraits song to I've Got a Little Just from the Mikado, which started, I refuse to be impeded by the principles of law, for I'm a magistrate, a near celestial state, and daily I'll declaim against excesses I abhor. With his wisdom that's innate, I detail what I hate. So we got it off our chest about magistrates. And then there was the prosecutor's song, to the gendarme's duet, with this stirring restraint, we prosecute, put in the boot, and so on.
You were also involved in the formation of the Criminal Bar Association, which is a significant body and significant to this day. What was the genesis of that?
Well, the criminal bar was kind of growing, but it was basically ignored. We had no representatives on the Bar Council. We were a small group, and the fees that were being paid were extremely small compared with other sections of the bar. You'd do a murder trial, you'd get a brief fee of $141. And
per day?
No, that was the brief fee. That was the first 6 hours. So that was the genesis. We wanted reasonable fees and to be taken notice of as an important group at the bar. There were 4 of us: Frank Vincent, myself, Colin Lovett, and a fellow John Hassett. who later became a Crown prosecutor, and that was how it started, and it grew from there, and we were able to negotiate with legal aid and public solicitor and so on, and the fees became more reasonable.
And it remains a significant body to this day.
Yes, it does, yeah.
John, let's get back onto the track of your career. When you've been at the bar, I'm thinking now probably 8 or 10 years, so you're an experienced and quite senior junior, you're briefed to appear in the Beach Inquiry. What was the Beach Inquiry and what role did you play in it?
Well, the Beach Inquiry was set up to inquire about the conduct of the Victoria Police. There'd been a number of complaints and the government had set up the inquiry. Barry Beach was the commissioner or chairman, and the lead counsel, I suppose you'd call it, was a fellow called Cairns Villeneuve-Smith, who was an extraordinarily good barrister. Anyhow, I got the Guernsey as his junior. On the other side, John Phillips, who later was Chief Justice, and John Walker, both very able criminal barristers, were appearing for the police. It went for 18 months, helped me buy a home. It was never out of the papers. Every day, and they even had a special logo for the police inquiry in the newspapers. They couldn't take photos in the court, but there were lots of photos of us walking up and down the steps outside the court. Anyhow, that as a result of that, Beach made a number of findings against various police officers, and the police threatened to work to rules and all sorts of things, which I found very ironical, because if they'd worked to rules in the first place, we wouldn't have had the inquiry. But from my perspective, the greatest thing that was achieved was the start of the movement to get electronically recorded records of interview. One of the problems was the armed robbery squad at the time. I got hold of all through the police liaison, a whole lot of records of interview done by the armed robbery squad over a period of years, in which the accused had claimed that they were fabricated. They were all unsigned. And we didn't have computers in those days, so I laid them all out on the floor of my chambers and went round looking from one to the other. And I found that in the unsigned records of interview...
Of many accused who may at that stage have been in jail.
Oh, yeah, they were in jail and probably had committed the offence, but that's another matter. But what came to light were all these common phrases, quite unique phrases. You know, I did it, Mr. X, being the police officer. I've had a good run up to now. It had to end. A whole lot of phrases like that. There might have been about 4 or 5 of these. So on the final day of the inquiry, I cross-examined this particular policeman, and having established that these accused were different ages, had different employment records, different educational attainments, and all the differences, then I hit him with the fact that they'd all used the same phrases. Well, he just said, oh, that's what they said. He had no explanation for that. And I invited him to produce to the inquiry any signed records of interview in which the same phrases appeared. And, of course, it never happened. So Beach made adverse findings in relation to that. So that was the start of this campaign to get interviews electronically recorded. It took a while. It wasn't until I became DPP and conducted investigations into all this that the government, under Jim Kennan, who was a very sympathetic and reformist Attorney-General, brought in the law that in indictable offences there were no admissions to be provided to the court unless they were tape recorded. And that, I would say, that's possibly my greatest achievement in the law, but certainly during my time as DPP.
It was interesting to me that around this time, I guess, or maybe at the end of the Beach Inquiry, you take up, or a significant part of your practice becomes appearing in the Northern Territory.
Yeah.
I'm assuming it would have been inconvenient. It may have been financially disadvantageous, and it lasted for several years. Why did you take it on?
Well, I suppose I've always been an advocate for social justice, and Frank Vincent had started to go up there, and he convinced me to go. Some other very able people had gone. Jeff Eames, who went on to the Supreme Court, he went up. He was the first one working for the Central Australian Aboriginal Legal Service. So I went up, and first time Frank and I were doing a murder I got off the plane in Alice Springs. I couldn't believe I was still in Australia. The way that Indigenous people, they didn't have anywhere, a lot of them nowhere to live. They were in the Todd River, and just the general atmosphere and attitude I found just appalling. I remember going out to the scene of the alleged murder on a settlement nearby. The house hadn't even been cleaned. There was blood all over the walls and the stench was extraordinary. Anyway, that was my introduction to Alice Springs. But so Frank and I and other people went up usually to do the murders over the next few years, and I found I were both spending about a third of our time in the Northern Territory. In fact, that the Northern Territory Police put in a claim for increased wages, and one of the grounds for the claim was that they were being cross-examined by Vincent and Coldrey. So they hadn't been cross-examined much up until then.
I would have thought that was a badge of honour, John.
Well, we didn't mind.
You must have loved the Northern Territory, John, because after doing that work up there for several years, you accept the position of Director of Legal Services at the Central Land Council. And I'm assuming that's not criminal work?
No, that was
land claims?
Land claims. I'd having done the criminal work, I'd formed the view that really people weren't going to be able to advance until they got some of their land back. They got onto their country and they could practice their traditional rituals and so on. The country that available was pretty narrow because it had to be inalienated Crown land. Now, pastoral lease was regarded as alienating the land, so it was limited. If the Department of Aboriginal Affairs could buy a pastoral lease, there was a loophole. They could then claim the land of the pastoral lease. So a fellow, Ross Howie, who later became a county court judge, and before him, Eames, they went from CALIS, the legal criminal law identity, to the Land Council. And they commenced these land claims. Of course, they were all old friends of Frank and myself. And Ross Howie persuaded me to go up and succeed him. And I must have been ready for another break, but the family came. And
was it difficult for the family?
Well, they had to change schools. My wife, Karen, then taught at local high school. I think overall, if you asked them, they'd be pleased they went. Completely different aspect of life up there. The land claims themselves were big productions. There were anthropologists and so on who have to interview the traditional owners, and we produced these big claim books. A lot of the evidence was group evidence, but we'd go out to the land and basically conduct the claims out there. We were just camping. It was just amazing. I remember being at Balgo, which is just over in the West Australian border, and the claim was in the territory adjacent. And I'm interviewing these old fellas, blokes saying, yes, in the old days we used to have bones through our nose. And I thought, oh, yeah. So I'm writing it down. I look up and they've all got these twigs instead of the bone through the nose, like this. Yeah. Then we went out onto their country, which they hadn't been on for years, but everything had been passed down in the oral history. We were coming along this area first of all, the leader kept pointing because we were trying to find a sacred site, and everything looked the same to us. And after about 5 or 6 hours travel, we got to the sacred site, spot on, which was fantastic, really. And then when we were coming back, there was all this savannah, looked identical to me, and he said, stop. And he said, if you dig here, we'll find water. And, oh, yeah. So they got out a shovel and dug this kind of square hole. It was dry. I thought, oh, okay. Then about a minute or two later, all this water started seeping in until it filled up with water. I mean, extraordinarily impressive people.
And this man remembered this from some time in the past?
He'd been told. He hadn't been on the land.
He'd never been there before?
No, he'd been told all about it. It was amazing. But we did mining agreements as well, and look, it was one of the best periods of my life, I think.
William and Lonsdale is brought to you by Greens List, one of the leading multidisciplinary barristers lists in Australia. Greens List believe in promoting conversation around the ideas and issues that shape not only our legal system, but our wider community.
John, I think you were there for about 3 years?
Yeah,
in that role?
About 2.5.
2.5 in the Territory. Then you come back in 1984. what to me was a strange position for you, having been a defence advocate your whole career. You accept the position of Director of Public Prosecutions here in Victoria.
Yes, it was a bit strange. I was concerned. It seemed to me that there was a movement afoot to weaken people's rights. There was talk about, in some types of cases, perhaps drug cases, reversing the onus of proof or reducing proof beyond reasonable doubt to the balance of probabilities. I must have been easily influenced, Michael. John Phillips, who was the first DPP, who again had never prosecuted, he said, "Oh, you should take it, John, you did a great job." So I agreed to take it on. Well, I only ever gave one press conference. It was Jim Kennan, as attorney, said, "I just want you to give the one, John." So we sit down and I was a bit mischievous. I said, well, the first thing I want to say is that I come to this job with a number of prior convictions. Jim kind of slumped and I said, my conviction in the need for proof beyond reasonable doubt, my conviction in the presumption of innocence and so on. And I had a few of those that got us a few headlines. That was about 6.5 years.
And as DPP, were you regularly appearing in court, prosecuting cases or possibly appeals, or were you mainly an administrator, a manager in the office?
No, I didn't prosecute anything. My record is complete. But look, there were endless meetings. They created this committee, which unfortunately became known as the Coldrey Committee. We looked into a whole area of the criminal law. I had police members and judges. There was quite a group of people. We changed the criteria for prosecuting in the first place to reasonable prospect of conviction. It had been a bit looser than that, but the test was if there was no reasonable prospect of conviction, you didn't go ahead.
Did this apply, so that's indictable offences, I assume.
Yeah.
Did it also apply to the Magistrates' Court and police prosecutions in the Magistrates' Court?
Well, we didn't have any control of those, so the burden of proof was still on the Crown to prove the case beyond reasonable doubt. We did tinker with the standard for committal proceedings and try and increase that a little bit as well. The one thing I did disagree with John Phillips on, and the Commonwealth DPP at the time, John had this view that if the person to be prosecuted was very high profile in the public eye, then even if you didn't reach the standard of reasonable prospect of conviction, you should prosecute to clear the air. Well, I was absolutely opposed to that. The same standard applies to everyone. It doesn't matter who you are. And that, I think, well, certainly prevailed in my time.
It was at this time that mandatory electronic recording of records of interview or became mandatory.
Yeah, that's
which
right.
you mentioned earlier.
Yes, that's when it happened. I remember Mick Miller, who was the Chief Commissioner of Police, coming to see me. Mick was the best Commissioner of Police we've ever had in this state. Terrific fella. And he said, John, let's try and have video, not just the audio, because that'll show the relationship between the suspect and the interviewing police. And we got that for the homicide, but it was a bit expensive for everywhere apparently. But that was a start, I've got to say. We looked at other areas too, taking of DNA, fingerprinting and so on. There was objective evidence and we made that easier with a number of safeguards.
So it was a rewarding time for you, that period as DPP?
Yes, it was.
But it leads on to you being appointed to the Supreme Court in 1991. I'm assuming after being DPP for about 6 years, that's almost a formality.
Yes, it is. It happened to John, myself, and then I think it was old Bernie Bongiorno was the next one, and then at some stage Jeff Flatman, Paul Coughlin and so on. There's a whole history of it.
There's a nice story, John, on you telling your dad about you being appointed to the Supreme Court.
Yeah, well, my father was in hospital. He was very ill and he clearly wasn't going to come out. And there was considerable delay between my retiring as DPP and the announcement of the appointment. So I said to Jim Kennan, well, my father's going to die, Jim. I want to be able to tell him that I'm going on the court. And Jim said, well, you go ahead and tell him. And I was very grateful. He'd always wanted to be a solicitor himself, but having left school at 14, it was a bit harder.
Absolutely. Interesting when you go on to the Supreme Court, you don't do criminal work for at least 12 months because you've been involved in so many matters as the DPP, and therefore you work in the civil division for those 12 months or more.
Yep.
On my reading of your life story, John, you hadn't done any civil work at all Zero. Starting with articles that Ray done. Maybe at the Land Council.
Oh, well, yeah, they were pretty unique cases, yes.
So how did you handle civil work?
Well, I didn't find it very easy. There were precedents that your mates on the court gave you in terms of charging a jury and that sort of thing. But it was difficult. I can remember doing a mesothelioma trial early on in the piece and a number of counsel, John Barnard, who used to terrorise young judges, he was for the defence and Jack Rush was for the plaintiff. I remember in the morning my tipstaff would come up and say, Mr Barnard wants the jury kept out. I get this sinking feeling in my stomach and what is it today? Anyway, the case went on and I finally charged the jury and John Barnard got up and said, well, that was appalling. The best thing you could do is to charge the jury and resign immediately. That was the gist of it. Whereas Jack Rush said that was an absolute paradigm charge. It should be taken and used by the Judicial Studies Board.
Do you remember the outcome of the case? Did it go Jack's way or John Barnard's way?
It went Jack's way.
With your career, John, and this is really a general question for people who are made judges, was it an easy transition from being an advocate to being a judge?
No, in some respects it was a relief. You'd see a witness and you'd think, oh, that's pretty good. How am I going to cross-examine him? You think, oh, I don't have to. That's what the barrister got to do. So that was a bonus. But the other difficult thing was you hear a submission from counsel and you think, gee, that's pretty good. And then you hear from the other side and you think, gee, that's pretty good. God, I've got to decide this.
And you've got to decide on a logical basis. You can't decide on which one you thought was better.
No, you go to a back room and try and make your decision. Look, it's like anything else. When you get more and more experienced, you get more confident. I remember George Hampel rather gloomily said to me after I was appointed, oh, John, he said, the first 5 years are the worst.
And that proved to be true?
Well, I don't think it was 5 years. But I got out of the civil after a year or so.
Back to crime where you were more comfortable.
Yeah.
I'm interested, you, John, and I think every criminal practitioner I've ever spoken to is a big fan of juries.
Yep.
Can you explain to us why you are such a big fan, why it's so important, why they do such a good job?
Well, first of all, there's a multiplicity of views rather than just you. Really, I think they bring democracy into the criminal law. They all come in with different experiences of life and they've got to judge the witnesses. And I've found them really pretty well spot on, I've got to say. Also, there's an ulterior motive, I suppose. It means you don't have to write a judgment. I mean, you get their verdict, they don't have to explain it. So overall, I'd be in favour.
Were there any cases that stand out in your memory where you thought juries got it wrong? Or you would have disagreed with their verdict? Yeah,
well, there's several where I would have perhaps brought in a manslaughter verdict where they brought in murder and vice versa, but that was always open to them. In 17 years, there were 2 cases where I think they got it wrong, completely got it wrong. They were both acquittals.
And you thought there was enough evidence there to prove guilt beyond a reasonable doubt?
Yeah, I did.
Some jurisdictions in Australia now have judges alone doing criminal trials, don't they?
Yeah, they do.
Do you think they're going to come in? Will we get them in Victoria because of the complexity of trials? And
I think we will. You may still have the option, but basically I think there's so much, the complexity is really the scientific evidence. Well, DNA is an example, but also some of the pathological evidence. But there'll be more and more science, I think, involved, and that's better, in some cases, better dealt with. And yet, judge alone.
If a judgment has to be written, it might slow things down, mightn't it?
Oh, it does slow things down. That's the problem. There have been a couple of these cases in New South Wales where it's taken weeks and the person's in limbo, probably in custody, awaiting the verdict.
But you think it's likely to come?
Yeah, won't be universal. There'll still be a choice.
In counsel advising a client on the choice, it'll vary from case to case, I assume. It's not you wouldn't think, well, they're going more often they'll go to a judge alone or more often they'll go to a jury.
No, I think you'd have to size up your client. If your client's going to give evidence and they're basically likeable and you think they can withstand cross-examination, you'd probably go with the jury. In some cases where you might feel the jury wouldn't take to your client, you might want the approach of a judge.
Judge alone. John, you're involved in a very interesting case, or a petition for mercy, in fact. Colin Ross was the man's name. He was convicted and hanged about 100 years ago.
Yeah.
Number one, how did the petition for mercy come about? Who cared 100 years later? And how does that sort of thing play out?
Well, it's an interesting case. They normally say that, justice delayed is justice denied. That wasn't the case in Colin Ross's case. The killing was New Year's Eve. He was arrested on the 7th of January. His trial was in February. His appeals were all dismissed right up to the High Court in March, and he was hung in early April. That was pretty swift. I won't say swift justice because it wasn't justice in his case. Part of the problem, the case involved a young 12-year-old schoolgirl who was murdered, and her body was found up near where the Eastern Market used to be in Melbourne.
Up in Burke Street there?
Yeah.
Near...
in that area.
Yeah, at the top there.
This fellow, Colin Ross, ran a wine saloon, and so some witnesses, some prostitutes who reckoned they'd seen the girl in his wine saloon. They weren't very reliable. I mean, he always denied it, so be clear on that, but there were some hairs found on a blanket in the wine saloon, and the so-called expert, he had some scientific qualifications, but he had none in assessing hair, said that the hair on the blanket belonged to the dead girl. As I said, the case went through and he was hung. A fellow called Kevin Morgan wrote a book, I think it's called The Gun Alley Murders, years later, and he was given access to the exhibits from the original trial. Now, normally they would be destroyed, but amazingly, because the hair was such a small item, it was still there as part of the Crown brief. And so the hair was analysed by a fellow called Dr. James Robertson, who's an absolute world expert.
And this is only, 10 or 15 years ago or something?
Yeah. Robertson said, without a doubt, the hairs are not human hairs, they're hairs of a dog. And this fellow had a dog. But that undercut the whole, basis of the conviction, really. I mean, he'd never confessed to anything. He denied it all the time. So there was then a petition of mercy from his relatives, his descendants, and ironically enough, the descendants of the young girl also joined in the petition of mercy.
Because the relatives of Colin Ross had gone to them and said, will you join us?
Well, I don't know what happened behind the scenes, but they were just as keen to get to the truth. It was referred to the Supreme Court, and Marilyn Warren, as Chief Justice, referred it to three of us.
Senior criminal judges?
Yeah, myself, Bernie Teague and Phil Cummins. I got the job of going through it all. The first difficulty was there was no transcript. However, in the Supreme Court library, they had newspapers from that time. They were bound in the huge volumes. Absolutely mad, because they're big broadsheets. So The Age and the Argus were the papers in Melbourne at the time. And so I got them up into my chambers. And I think most of the reporters in those days were good shorthand writers. So the descriptions of what occurred and the evidence was extremely detailed, and also coincided. There was no discrepancies of any note in the reports in the newspapers, so I was able to use that as the basis for what had occurred. So anyway, I wrote this piece which Bernie Teague and Phil Cummins agreed with, and so we obviously couldn't have a retrial, but it was open to the Attorney General. Rob Hulls was the attorney, to pardon Ross, and he did so.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning, hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting.
John, you retire from the bench, from the Supreme Court in 2008, but you are on the Adult Parole Board for maybe the next 4 years, I think?
I think that's about right, yeah.
Parole's very controversial at the moment. Well, the popular press keep highlighting events where people on parole reoffend, particularly in violent crimes, obviously. Can you tell us how the system works, and are there any changes that you think could be made to improve it?
I think the first thing that ought to be said is that parole is essential if people are not going to be released into the community without any supervision at all. It's important that there is supervision. Once they are released, the key factors that I found in not reoffending is obtaining employment and obtaining stable housing. If you don't get those, there is a chance that you'll reoffend. People released on parole have a parole officer, this is in my time anyway, have a parole officer assigned to them. They go for interviews, they're asked about problems they might be encountering and so on. And they have to come in and also report to the parole board. This, again, was in my time. I'm not sure what's happening now. It was an interesting time. We sat in panels of 3. Often I'd sit with Darcy Dugan, who was, the fantastic chief magistrate in his day, and Jim Berg, an amazing Aboriginal leader. Sometimes if you had an Indigenous bloke, particularly a youth, Jim would say, now it's time for a little chin chat, he'd call it. And they'd start to tremble a bit and Jim could really read the riot act, often starting with, I know your parents and I know how they'd feel about your conduct. And, he was terribly effective.
And because there's a culture of great respect for elders.
Yeah.
Therefore, people like Jim, the offender, has a natural, not exactly fear of them, but great respect for them.
Great respect. Oh, yeah, well, Jim, still going, Jim, but he's a man who commands great respect. So that's the way it's got to work. The workload in my time was enormous. You'd come in and there'd be a pile of folders there. Some you could deal with on the papers, others you'd have call the people in and you'd get a report first from their parole officer. We used to go to the prisons a lot, which was always, I thought, a very worthwhile exercise. In later years, it tended to be all done by video. I think you really need to be there, but then that's all changed. It's, as I said, important for the safety of the community that we have parole.
But in an ideal world, there would be a job and housing for people who are on parole, and that must be a great difficulty, really.
Well, it is. And I don't know that people understand crime as, well, understandably, they don't understand it as much as they should, because if you look at a so-called criminal, you look at somebody who's usually been socially deprived, poorly educated, had a complete, because of those factors perhaps, a lack of opportunity in life. They often experience poverty and in many cases they've got some sort of mental disability. I think the kind of master criminal is very rare in our community.
John, for 15 years after you retired, a long time, you chaired the Victorian Institute of Forensic Medicine.
Yep.
I wasn't aware of its existence and I got no idea, or I didn't until I read the papers, what it does. So what does it do and where does it stand in the system?
Well, what happened was that after John Phillips appeared in the Chamberlain trial and Lindy Chamberlain was convicted, John was appalled by the standard of scientific and forensic evidence presented to the court, the so-called experts from the Northern Territory. Following various episodes, we had the Morling inquiry. Judge Trevor Morling looked into the Chamberlain case and was highly critical of the so-called expert evidence in that case. So what John set out to do, well, I think he started probably when he was DPP, but was to create a totally independent institution that could provide expert evidence to the court in all cases. So John Cain Sr. was very supportive, prime mover, as was Jim Kennan, the attorney at the time. The idea was that they would not only present evidence in terms of pathological evidence, cause of death, but toxicological evidence about drugs, and also evidence about violence when the person's not dead, cause of injury. So that was created, and a fellow called Stephen Cordner, Professor Stephen Cordner, became the first director. He was there for about 24 years. Stephen Cordner, in my estimation, and not just mine, would be probably the foremost forensic pathologist in the world. It's a big call, but he is excellent. Even when I was a judge and you saw Stephen come through the doors of your court, you thought, well, now we're going to get some straight-shooting, reliable evidence delivered in a way that juries could understand. So that's the organisation I joined. John Phillips, when he retired from even before he retired from the court, he was the first chairman. Then he was followed by Marilyn Warren as Chief Justice. And then Marilyn asked me if I would take over from her because the workload was too much being Chief Justice and on the council. So I was happy to do that. But it is, as I say, an amazing organisation. We have people coming from all over the world to study there, really. We can't take too many, but people do come and study. We've set up organisations in Africa and in Asia where we hold conferences and so on. But it's I found it very rewarding. As to how it fits in with coroners, well, the coroners they're magistrates who have been assigned the coronial role. They couldn't function without the Institute because the Institute provides all the causes of death, the toxicology and so on.
So all of the scientific evidence that goes before magistrates relating to the death of a person comes from the Institute?
Yeah.
Oh, okay.
Yeah. Of course, that enables the coroners to make a finding, and there's close liaison, of course, between the Institute and the coroners. But the other role, of course, of the Institute is to give evidence in crimes of violence and murders and so on, drug cases. For example, we had our chief toxicologist give evidence in the recent mushroom case that everybody knows about.
It's interesting. I mean, I wasn't unaware of its existence, but clearly when you think of that mushroom case, extremely important in the criminal justice system. John, we better wrap it up. Don't want to embarrass you, but you've had a long and illustrious career. That goes without saying. But I'm always interested to hear what people like you would say to the young John Coldrey in the 1960s, the law students of today, the young barristers and solicitors of today. Looking back over such a career, what would you say to them?
Well, I saw that question, Michael. I think the first thing I'd say to law students and young barristers is recognise your luck. The greatest hogwash, in my view, foisted upon the community is the assertion that all persons are born equal. In the lottery of life, people are not born equal. They inherit different physical and mental capacities. Some people have loving and nurturing parents, others suffer from domestic violence. Some are born into wealth and privilege, others into poverty. So if you're studying law or you're practising law, you've experienced, for a start, genetic good fortune. It's not your achievement that you're bright enough to do law. It's your random inheritance. So always bear that in mind. And if you use it to serve the clients that fate throws your way to the best of your skill and ability, then good luck to you. You're doing something worthwhile. If your overriding objective is to make as much money as you possibly can, well, then I'd say to you, you'd be better off trying business as a profession. The other thing I'd say is whatever area of law you undertake, your most valuable attribute, your most valuable possession is your integrity. Never, ever sacrifice that to the short-term achievement of a result for a particular client. So finally, I think I'd say good luck. You'll be part of an honourable profession with the capacity of achieving great good for the community in which you live. I think it's enough pontificating from me.
I don't think it's pontificating, John. I think your life and career bear those words out, and therefore I thank you on behalf of everybody for such a rich and enlightening conversation we've had this morning. Thanks very much.
Well, thank you, Michael. I hope I haven't rabbited on too much.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue that discussion here today.